Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with theft of electronic scooters. Let's see here. My 15-year-old son, a juvenile, in the company of other friends, conspiracy, stole scooters to modify them. The police came to my house and my son was arrested. They found 9 scooters in my house. Well, first of all, were you aware that your son was doing this? Because if you were, you could theoretically be charged with aiding and abetting. Now, assuming you were not aware of this and your son was doing this, the problem is that each one of these scooters is worth more than $950. So taking each one of these scooters would be considered grand theft here in the state of California under Penal Code Section 487, which carries up to 3 years. Now, because he is a juvenile, he is not going to get sent to state prison, but he could still have to serve time at a juvenile detention facility. Now, because he did this with friends, he is also going to be charged with a conspiracy, which is also a violation of Penal Code Section 182, which also carries up to 3 years. Now, he could be charged for each separate scooter because they're theoretically separate offenses. And so let's say he had 9 scooters, they could file 9 separate charges for Penal Code Section 487 plus the 182. And in a situation like this, if it looks like the evidence is clearly against him, you don't want to take this case to a trial, because in juvenile court there is no trial by jury. There is no jury trial, it's trial by judge. And generally speaking, the judges, they're quite a bit more conservative and they tend to convict people far more often than juries. So in a situation like this, you may, your attorney may be able to discuss this matter with the DA's office to see if there's a way that it can be, or at least that the punishment could be one that does not include jail time. Probably a lot of community service, a lot of classes. Obviously, there's going to be tons of progress report hearings. They're going to want you to make up for this. But the good thing is that because your son is only 15 years old, once he is 18 years old and off probation, he would actually be able to petition the arresting agency to seal his arrest record so that in the future, this does not affect him at all. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation in court, call us now for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was accused falsely of rape. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.